grateful for this opportunity to do so on a very important subject. I've been on the island now since September of 2021, having been appointed in March of 2021, back in the days of COVID. And I wasn't able to get here exactly in March because I was also working on Montserrat as the designated judge. And I therefore spent some months on Montserrat, also during COVID, before I made my way over to the wonderful, very beautiful islands of St. Kitts and Nevis. So before we deal with the sentencing guidelines, I think a little bit about my background. There may be some folk who are curious. Who am I? Well, I am Iain Charles Morley. I was born in Dublin, in Ireland, and I was educated in Ireland, so I am in fact Irish. And having completed my schooling over there, I was clever enough to go to the University of Oxford over in England, where I read law. And on completing my law degree, I became a barrister over in London in criminal law. And I was busy at domestic criminal law, all sorts of types of criminal law, from speeding offences all the way through to murder offences, for a number of years before I was invited to go and help in international criminal law. And I found myself in The Hague, where I was defending in a case, helping in a team, the president of Yugoslavia, Mr. Milosevic. I then went on to prosecute for the United Nations in the Rwanda genocide, which was a court established in Tanzania in a town called Arusha. And there I met the distinguished, notable jurist, Sir Deniece Alleyne. And he will be well known to Catticians and Novesians. And he is well known around the world. And Sir Deniece and I became acquainted. I was a prosecutor in his courtroom. And to cut a long story short, there came an opportunity for me to help in the Caribbean. And I found myself, after I took silk, which means I became Queen's Counsel, because the Queen was still alive then, but I'm now King's Counsel, because one changes from Queen's to King's Counsel depending on who the monarch is. But I became Queen's Counsel in 2009. I went on to help prosecute the assassination of the Lebanese Prime Minister, Rafik Hariri, again back in The Hague. And after a little bit of further work over in London, where as Queen's Counsel I did some very serious, heavy work, both prosecuting and defending, I came out to the Caribbean in November of 2016. And at that time, I was appointed to, within the Eastern Caribbean Supreme Court, within the 9 islands of that court, I was appointed to Antigua and Barbuda, where of course I met Mr. Smith, the current DPP, and I was also appointed the designated judge to the island of Montserrat. So I found myself on Antigua for 4 years, where I did all sorts of work, becoming the senior judge there on that island. And I've also been, in parallel, the designated judge for Montserrat between November of 2016 and November of 2023. So I did 7 years working on Montserrat, all sorts of work, criminal work as well as all the civil work, and was doing mainly the criminal work on Antigua. But as you'll remember from what I said earlier, I was appointed to St. Kitts in March of 2021. So I moved from Antigua to St. Kitts, Antigua for 4 years, and I'm now just over 3 years on St. Kitts. I'm also the co-chair of the Sentencing Guidelines Committee. I run the meetings, and we have a team. And the Sentencing Guidelines Committee was established in July of 2017, and I'll have more to say about all of that in a moment. I've also been one of the primary architects of what's known as the Model Sexual Offences Court, which began its work in Antigua, where I was the appointed judicial officer. And I've also been active in promoting what's called case management, that is to say, a more active approach to trying to get the cases moved through the list. And I think folk will know that there have been a lot of delays in cases throughout the Caribbean region. And one of my tasks has been to try and find ways of reducing delay. And as Mr. Smith will remember, when I first arrived in Antigua, we had quite a backlog. And with a lot of work from the prosecutor's office, as well as the defence, we got through a lot of the backlog in the 4 years I was there. We pretty much cleared it by the time COVID hit. And COVID, of course, created its own new backlog. I cleared the backlog as well on Montserrat, both pre-COVID and post-COVID. And one of the reasons why I'm here on these beautiful Federation Islands is to clear the backlog here. And I can say there's a lot of work to be done. It's not just the terrible crime rate now. That is work that will come into the courtroom in the coming future. There's a lot of work that's been stuck in the system for a while, and what we're doing is we're pulling it through the system and getting it dealt with. We have a very high turnover of work. We're a very active court. All the lawyers are working very hard, and so am I. So today's topic is sentencing guidelines, and what are those? And this is a very important question for folk. It's very clear to me that it's a subject that the public may not know very much about. And it influences a lot of the court work. People who get into trouble with the law need to know what could be the sentencing, how will it be structured, what might be the outcome, what happens if they plead guilty. Is there an opportunity to negotiate what they plead guilty to? Can they get an early indication of what their sentence might be if they pleaded guilty? And all of this is work that has been undertaken by the Sentencing Guidelines Committee. And we have promulgated, we have published guidelines in respect of 22 offences. And that helps folk in the 22 most common offences to have some idea when they sit down with their lawyer as to how this may all play out. And I think there has been for a long time a great sense of uncertainty about what the sentencing is going to be and how it's going to be structured. And that may have created a fear on the part of people about going to court because they really had no idea what may happen there. Well, those days are supposed to be over. And the lawyers, both prosecuting and defending, are seized of these guidelines and they are familiar with them and they are able to advise defendants and the court about where a case falls within those guidelines. And one of the things we want to get across today to the good folk of St Kitts and Nevis is sentencing is no longer a mystery. It's structured. And whilst no two cases will produce the same sentence, they will all follow the same structure so that folk can plot where their case may fall within that structure and get some idea as to what the sentence would be. And that sort of foreknowledge, that foresight, is designed, we hope, to help people understand the law better and what the risks are that they face when they come to the courtroom. It's been a project ongoing since July of 2017, and it's on the back of there being lots of sentencing guidelines in lots of other Commonwealth countries. You'll find them in New Zealand and Australia and in South Africa and in the UK and in Ireland. You'll find them in Jamaica, in Trinidad and Tobago, throughout the Caribbean region. You'll find them in Canada. It's part of a project which has arisen in the Commonwealth and the other common law jurisdictions over the past 15 years or so. And I'm pleased to report that many of the guidelines that have been created by the Eastern Caribbean Supreme Court, that's us, have been adapted and adopted in other Caribbean countries. So folk need to know that there is a sentencing regime that can be understood. It's not a mystery anymore as to how sentencing is structured. Now, I hope that is a good introduction to what we're going to talk about, and I'll pass the ball back to you, Deniece, as to where you want to go next, and perhaps to have an introduction of our DPP.
Yes, well, as you would have heard, folks, we have the perfect person to deal with this particular topic, the person who has been largely responsible for getting us where we are in terms of sentencing. And we'll have the DPP introduce himself, and then we'll get right into it. I think I'll begin with a discussion of plea bargaining. But first, let's hear from Mr. Smith. Tell us a bit about your work and how you got here.
Yes, thank you. Good morning to St. Kitts and Nevis, Sugar City, and to all the listeners beyond our shores. It's a privilege to be here this morning, to be able to impart knowledge and wisdom and understanding to the members of the public. Sentencing is an exercise which is very complicated, often referred to as something that is not an exact science. And a lot of things go into it, and a lot of times persons don't quite understand all that is involved, and as a result, they may be unduly critical of the process. So the purpose of this morning's exercise is to try and give the public an idea of the rationality that's involved in the whole exercise of sentencing. Insofar as I'm concerned, the Director of Public Prosecutions, I graduated from the Norman Manley Law School, and I'll be much briefer than the learned Judge Cavalry at the time. I've been a prosecutor from 2004. Prior to that, from 2001 to 2003, I was a defense attorney in a notable attorney's office, Mr. John Fuller, from Antigua. I am from Antigua, proudly from Antigua. I have been a prosecutor until around 2019 when I took up a role of Director of Law Reform, and I'm so grateful for having taken up that role up until 2003, because coming out of the prosecution department, I was able to look into the system from the outside, and I saw that there was a great need for change, and it has definitely determined my outlook as to how I deal with the system and how I look at the legal system here. For example, in St. Kitts, I look at it with a reform approach. There are lots of things that need to be done, but in time, one by one, they will be done. And so here I am today, contributing to the discussion, and I look forward to a very fruitful exercise. I'm hoping that the public will definitely learn from it.
No, there you have it. Our learned judge in the criminal circuit and the Director of Public Prosecutions. Now, His Lordship did mention that one of the points of the sentencing guidelines is to remove the mystery from this part of the system so that defendants have some idea of what to expect given the nature of their case, and it could influence the course that defendants as well as their counsel decide to take given what can happen in various scenarios. Now, I know prior the practice of plea bargaining, which came to me during His Lordship's discussion, was not allowed in our system. but there was some discussion towards bringing it in. And I think that would be a good place to start because it's something I think people are vaguely familiar with. We see it a lot on TV. And it would, give us a good starting point in terms of, from a defendant's point of view, you're looking at the case that you have to face, and you are calculating, okay, what's the best course of action for me? Is this something that is available here? How does that work? How does that discussion go? Given, once you are before the court. So first we'll ask Justice Morley if it's even allowed, and then we'll go into how that kind of discussion goes.
Well, thank you, Deniece. But I think before we get into something like plea bargaining, I think we need to understand the structure of sentencing. And I think we also need to understand what guidelines there are. And I think folk would probably welcome knowing what the list is of the 22 offences for which there are currently guidelines. And I can mention to folk that there are some more coming shortly when they get published, we think, in the new year. But the 22 so far are as follows. There are currently sentencing guidelines for murder, manslaughter by reason of provocation, manslaughter by reason of an unlawful act, causing death by dangerous driving, theft, robbery, burglary, aggravated burglary, corruption, blackmail, fraud, money laundering, rape, unlawful sexual intercourse, aggravated unlawful sexual intercourse, indecency, incest, inflicting unlawful violence with intent to cause serious harm, inflicting unlawful violence, reckless as to the harm caused, kidnapping, possession of firearms, and drugs. So I hope folk can see that what might be called the bulk of the criminal calendar has been covered by those 22 guidelines. And I think what is helpful next for folk to understand is that there is a 6-step approach which takes place when a sentence is constructed. And folk can find a lot of this on the court website. And it occurs to me, it's not well known that many of the sentences are captured on the court website. That is the website for the Eastern Caribbean courts. That's eccourts.org. And one will find there lots of information about how sentences are constructed with lots of examples of sentencing so people can familiarize themselves with the process. It's not a secret. It's all out there, available to be read and consumed so that folk are better informed when they wish to discuss sentencing outcomes. Now, the 6-step process in any sentence is uniform. Every sentence goes through these 6 steps. It does not produce the same outcome because every case is a bit different, but each step is considered in every case. And the first step is an assessment of the offence. And as a result of the guidelines, the assessment of the offence involves an assessment of its seriousness and its consequences. And there is a starting point which is derived from that first step, from the assessment of the consequence and seriousness of the offence. And when you've got your starting point, the next question is step 2, an assessment of the offender's circumstances. What's known about them before the court, what their background is, what's their personal circumstance. And when that's factored in, there is the third step, which is an assessment of whether the defendant has pleaded guilty. And if the person has pleaded guilty, there is, if it's been at an early practicable opportunity, a 1/3 discount which is applicable for an early plea. And folk need to be aware of this. A 1/3 discount for early plea. And that is the third step that we look at. The fourth step is, having assessed where we've got to by reference to assessing the offender, assessing the offence, has there been a plea, we look at what's called totality. And that is, sometimes there are a number of offences which are all being dealt with on the same day. And totality, therefore, involves an adjustment of the sentence depending on how many offences are being sentenced. So the fourth step is to adjust for what's called totality. Very often there's just one offence which is being dealt with, but sometimes there are a number. And there is an adjustment made at step 4 for totality. The fifth step is that there is an adjustment which must be made for time spent on remand. And that is a feature which is factored into the sentencing process. Step 5 is time on remand must be allowed to be set off against the sentence which is passed. And finally, the sixth step is whether there are any ancillary orders, any additional orders that need to be made, like, for example, the confiscation or the destruction of something, like the destruction of drugs, if that's what the case has been about, or the confiscation of or destruction of, for example, firearms if they've been seized. So the sixth step is ancillary orders. And every sentence, therefore, goes through those 6 steps. I'll remind you. Step 1, assess the offence, produce a starting point. Step 2, assess the offender. Step 3, has there been a plea of guilty, and if so, what credit follows if there's been a plea of guilty? The earlier the plea, the greater the credit. An early plea attracts 1/3 off the sentence. The fourth step is an assessment of totality. The fifth step is to adjust for time on remand. And of course, the sixth step is ancillary orders, are there any to make? Now, that I hope helps folk to understand the sentencing structure in the mind of any judge nowadays, and also in the mind of any lawyer. Your lawyer needs to know about the sentencing guidelines, because they will therefore know what those steps are and how the judge is thinking about constructing the sentence. Now, having said all of that, I'll just turn to the DPP and see if he's got any observations about the structure of sentencing guidelines and how they've been of assistance to the work of the lawyers. So, DPP, what thoughts?
Well, I mean, we can start first. I just want to add to what Justice Morley said with respect to the starting point. The starting point, when you consider the seriousness of the offence and its consequences and the circumstances of the offender, on the other hand, it leads to a particular point, already referred to as the starting point. And that starting point is also associated with a range of the sentence. So, in other words, once there's a starting point, there's a outer limit with respect to what this court can work within in terms of sentencing an individual. And they will go up or down depending on mitigating factors and so on, according to the other stages in the sentence already referred to by the judge with respect to that. So I just thought I'd want to point that out. one of the important questions that persons often consider, are the sentencing guidelines mandatory? Well, the practice direction, which is issued by the court, indicates that the judges must follow the sentencing guidelines unless it's not in the interest of justice to do so. So there are circumstances where the judges can go outside of the normal range, and so on and so forth. And if they do so, they must give reasons for the decision, so the person being sentenced and members of the public can understand what exactly is going on. So I thought I'd make reference to that as well. I can give you an example of a situation where the court can adjust, for example, a particular sentence. Situation where a court maybe assesses a particular offender as being dangerous, right? And when I say dangerous, the court having regard to, for example, something called a social inquiry report, which is a report into a person's circumstances after he'd been found guilty, and it's normally done by a probation officer or some social worker in the government, right? If considering all of that, and in addition to, for example, his previous convictions, things that he had been found guilty of and so on, and the court thinks that, or assesses that there is a risk that he may continue to commit either the same offense or similar offenses, the court can adjust the sentence further upwards outside of the guidelines for that. But again, it must state the reasons for that. Now, the sentencing guidelines have been useful in practice. And I can think of none other than a recent situation where I had to apply the guidelines. I'm sure many of the persons in St. Kitts and Nevis are familiar with the Nardis Maynard case, a murder which took place somewhere around 2003. Well, 2003. We weren't using 20 at that occasion. But one of the things, for those who weren't aware, that is a particular murder that went all the way to the Privy Council. And the Privy Council made the decision that the Director of Public Prosecutions is to determine, the Court of Appeal rather, to determine whether there is to be a retrial of the matter. Well, whether there's a retrial of the matter really depends on the exercise of discretion of the Director of Public Prosecutions. And of course, there are a number of factors coming out of a case called, I think, Dennis Reed, whereby the DPP can determine whether there is to be a retrial or not. And I had a look at that case. And one of those factors that the Director of Public Prosecutions can consider is, what is the likely sentence in the case of a retrial? And if once that likely sentence has been determined, has he substantially served that particular sentence? And that was one of the key factors in determining the exercise of my discretion not to retry the matter. I mean, I had written a decision on that whole issue, which is 21 pages long, if it is available by request, because I believe in the principle of open justice. There must be reasons for especially important decisions. And so the point I'm making is, looking at the sentencing guidelines, I was able to see, okay, if he was sentenced according to the sentencing guidelines, he has substantially served a sentence if the sentence would have been passed today. And so that was one of the key factors in terms of my decision, exercise of my discretion, not to have a retrial of the matter. So that is one example. You made reference to plea bargaining earlier. Some people don't like the idea of bargaining in a court, especially when it comes to crime. There's a sort of a nastiness seem to be associated with that. But I want to make a point. Whether you call it negotiation, I want to look at it in terms of what is the fair disposal of a matter in the circumstances. Now, a lot of people may not realize it, but the system benefits a lot from guilty pleas, especially early guilty pleas. A court docket at any given time, I'm talking about the High Court docket. I know last term it was somewhere in the region of about 50-something or so matters, but it has gone up significantly since. And I'm sure the public may be familiar with the fact that there are 3 assize terms per year. When I say assize terms, a criminal session where the cases are tried. And on average, maybe about 12 to 14 weeks per session, and so on and so forth. If you have over 50 cases on that docket, some of them are long, some of them are retrials, some of them are complex, and so on, there is absolutely no way. I estimate that you can probably do maybe about 7, 8, if you're so fortunate, out of that. The point I'm making is the system depends on guilty pleas because it's not able to try every single case. And hence, in appropriate circumstances, it is rational or reasonable for the DPP and the defense counsel to determine what may be the just resolution of this matter, having regard to different features of the particular case. And the sentencing guidelines come in to determine, well, there being no magic or mystery as to where your sentence is likely to fall. Because remember I said, even though there's a starting point, there's a range in which. And the sentencing guidelines have been of assistance in, for example, defense lawyers determining, okay, my client can plead to the lesser account. When I say the lesser account, or the lesser offense, I'm thinking in a circumstance where, for example, a person may be charged on a 2-count indictment in the alternative, wounding with intent, which is the most serious offense, wounding with intent to do grievous bodily harm or really serious harm, and the alternative to that would be unlawful wounding. I think the first count has 20 years maximum imprisonment, and the second one carries a maximum of 7 years imprisonment. I mean, it's obvious to see that it would be within the best interests of the defendant if he can get a plea on that. But at the same time, it has to be rational. So the point I'm making is that the sentencing guidelines can take a lot of the guesswork out of where your sentence is likely to end up, and hence persons would be more likely to plead guilty. Now, in appropriate circumstances, of course, are more forthcoming. Now, the sentencing guidelines, I think, can also be used creatively. And when I say creatively, for example, like I said, I have a law reform background and a law reform outlook towards the criminal justice system. You may be aware, or some persons may be aware, that the proposal is to have some criminal procedure rules for the Eastern Caribbean. And I've been asked to have a look at that. And one of the things I want to propose in that is having something called custody time limits. What are custody time limits? You would have heard reference to the term remand. And for those who are not familiar with the term remand, it simply means when you've been charged with an offense and you've not been granted bail after being charged with the offense, having been brought before the court, you're kept in custody. And that period that you spend in custody before your matter comes up in trial or for trial is known as being on remand. Right? Now, particularly in St. Kitts, there are situations where there are a lot of persons on remand. Right? And I see that St. Kitts and Nevis in particular is a litigious society, especially where the issue of remand is concerned. And I think having a rational approach to the issue of custody time limits, in other words, sentencing guidelines could work out, all right, like I said, there's a range for a particular type of offending. If somebody at the outset could determine what that range is, and we know what the outer bands of that sentence is, then in the custody time limits, what we would have is a principle whereby if somebody is either close approaching or has approached that outer limit, they must be released, right? Because otherwise, serving beyond that would amount to unlawful detention or unlawful imprisonment. So I think having custody time limits is important with respect to the criminal procedure rules. There are principles in relation to custody time limits in, for example, the Belize criminal procedure rules, but I'm not quite advocating for something quite along those lines, but I'm thinking that the sentencing guidelines could be useful in terms of determining that. And also, too, sentencing guidelines as part of a broader early guilty plea scheme. What do I mean by an early guilty plea scheme? I think that there ought to be rationality in terms of, the amount of discount which is applied when a person pleads guilty. I mean, you heard his lordship indicate that you are entitled to a discount of 1/3. And people don't even like to hear the whole concept of discount because it sounds like you're in a supermarket and, discount is associated with sale and so on. But up to 1/3 discount for plea at the earliest available opportunity. I would go as far as saying that time should start to count from where an accused person gives his informed consent to pleading guilty to an offense. And when I say informed consent, in other words, the accused must be told of the consequences of pleading guilty. And here is where, when the person comes to the court for the first time, I mean, it's reflected in the new criminal procedure rules that he must be told about the advantages of pleading guilty and so on and so forth. That is part of the process. But I think another question that ought to be asked, especially when he's represented, the court should ask the attorney, have you, sir, consistent with the practice direction, have you informed your client as to the likely sentence that your client is likely to suffer if he pleads guilty to the offense? Right? Right. And that happens at an early stage. And once, like I said, there is informed consent on those two particular points, that is when time should run. Right? Otherwise, you'd have people thinking that they can plead guilty maybe just before the verdict and still get 1/3 discount. I think that is not a proper exercise of that right to plead guilty. So I think having a rational approach to the system of pleading guilty would help the system. And here is where sentencing guidelines could help.
No, the sentencing guidelines, this is a judicial, as part of the judicial process. Mm-hmm. It is within the purview of judicial officers. But of course, the Parliament plays their role as well. And in St. Kitts and Nevis, we've recently had increases in sentences for firearms offenses, given the circumstances. So how do those interact? The sentencing guidelines and the legislative framework for sentencing.
Well, if I can help with that, and there are other things to say following what the DPP was talking about. Legislation gives you a maximum sentence. And the sentencing guidelines, the 6 steps which I have mentioned, at step 1 finds a starting point within that maximum. So when you assess the offence, you will find when you look at the sentencing guidelines that there is a grid, and the grid helps you to weigh the consequences and the seriousness of a particular offence, and by then categorising the consequences and seriousness, the grid will give you a percentage of the maximum sentence, which is your starting point. Mm-hmm. And the starting point is adjusted upwards or downwards within the range, as the DPP has described. But the sentencing guidelines don't replace the legislation. They work hand in glove with the legislation, and they help the court and the lawyers to see where the starting point is within what's otherwise the maximum, which legislation has just said is available for an offence. And folk need to understand that the court is not almost ever engaged in the business of passing the maximum sentence. the maximum sentence is an example of the very worst form of a particular offence. And in theory, it's very difficult to imagine what must be the very worst form. That there may be an even worse form that you can imagine the day after you've thought you've got to the end of that analysis. So the maximum, if that's what people see in legislation, they may think, oh, that's what I'm going to get if I'm guilty of an offence. It's not so. You don't get the maximum, or almost ever. You have an analysis of the offence guided by the guidelines, which finds a starting point within that maximum. And we work from there. So with regard to the change in the law regarding firearms, for example, where the sentences have been as maxima increased, the guidelines still find the percentage within the grid. And we work from that percentage as the starting point within the grid. So yes, the sentences have gone up, if I may mention to the good folk of St Kitts and Nevis. If you've got an illegal firearm, watch out. The sentences have gone up. And the sentencing guidelines, working hand in glove with that increase in the maximum, will produce much heavier sentences than there have been before. And if I can just follow up on some of the things that the DPP was saying about what's called plea bargaining, I want to echo, I want to endorse what he had to say about the word bargaining. We're not in the business of being in a marketplace haggling over the price of a jug. Bargaining is the wrong word. It's a word which has slipped into chit-chat. What we're actually doing is we're trying to find the fair outcome with regard to an allegation. And it can be characterized in different ways. It may be there's a dispute about certain aspects of the facts. And what's supposed to happen when there is a discussion about what is the fair outcome as to what offence the person is really guilty of? What's supposed to happen is that the lawyers talk to each other. The prosecutor talks to the defence lawyer, who talks to the prosecutor, who talks to the defence lawyer. So there is a gathering of those two legal minds with a view to negotiating what is a fair outcome from the point of view of both sides, prosecuting and defending. And one of the features that the sentencing guidelines is designed to promote is precisely that talking, because there may be a perception that lawyers on one side don't talk to the lawyers on the other side. That is wrong practice. Lawyers, as professional people, are expected to discuss cases with each other to find the way forward which will accommodate everyone's interests. And we are hopeful that the sentencing guidelines are going to change what is perhaps a circumstance in many of the islands that the lawyers don't talk to each other. And I can report from my experience that that is changing because the sentencing guidelines invite consideration of where in the guidelines on the grid does the offence fall. It naturally creates something to talk about between the prosecutor and the defence lawyer. And that's a good thing, so that people who are in trouble with the law have their lawyer, the defence lawyer, working on their case with a view to the best outcome, rather than tipping into court and seeing what happens. No, we want folk working on it outside the door of the court, before we get anywhere near the judge. Lawyers talking together. And to that effect, we've got downstairs in the new court building that we work in, we've got something which is called the Advocates' Lounge. And that's where the advocates, in theory, are able to assemble and talk to each other about what's the best way to deal with the case. So it is anticipated that there will be discussion about a fair outcome. It's called plea bargaining, but it's not haggling like in a supermarket. It is a discussion between professional people, guided by the guidelines, as to how best to bring the proceedings to a fair conclusion for everyone concerned. And folk need to understand the business of sliding credit. If you enter your plea at an early practical opportunity, you're going to get your 1/3 discount, and that can be a lot in some cases. But if you dilly-dally and stall, the credit starts to slide, and it's no longer 33%. It might go down to 25%, might go down to 20%, might go down to 10%. At the door of the trial, with the jury assembled, everybody ready to have the trial, and you enter your plea then, the credit might only be 5%. So it needs to be understood that it's important that defendants discuss with their defense lawyers what is a sentencing outcome and what will be the advantage of an early plea. And this means every defendant, everybody who finds themselves in trouble with the law and they've got a lawyer, they ask their lawyer, what do the sentencing guidelines say about my case? Make sure your lawyer works your case and that they look stuff up rather than just drift into court and see what happens. Those days should be over. Every defendant, anybody in trouble, needs to know their lawyer works for them. The lawyer is accountable to the client, and every client, every defendant is entitled to say to their lawyer, tell me about the sentencing guidelines. How do they work? What's the likely range of the sentence here? What's the discount if I plead? Help me to understand the lie of the land so that every defendant is better informed. Because in addition, there is another feature to all of this, which folk need to know about. In many cases, not all, but in many cases, your lawyer can ask for what's called a sentencing indication under a principle created by a case called Goodyear. A sentencing indication, in the right circumstances, allows a defendant to know what the sentence would be if there was a plea of guilty that day, there and then, essentially. And you don't necessarily have to have entered a plea of guilty. You can know from the judge what the sentence would be. And your lawyer must always advise you not only of the sentencing guidelines, but of whether or not you may be entitled to a sentencing indication. And this helps folk to know where they stand. Now, I have to stress that a sentencing indication doesn't always arise in every case, but it arises in most of them. And if a person is genuinely wondering about a plea of guilty because, well, they're guilty of something, then a sentencing indication may be something that needs to be raised with the judge. And in the background, I hope folk can see the lawyer should be negotiating with the prosecutor to establish the fairest outcome, to establish what should be the right charge to which a person pleads guilty as part of the plea bargaining that's going on in the background. So the lawyer's work is talk to the other side, know the guidelines, negotiate the situation, and where appropriate, ask for a sentencing indication, rather than the lawyer just drifts into court and sees what happens. Those days should be over, and defendants are entitled to know more from their lawyer and sometimes to know more from the court. Now, people may wonder, well, where is all of this to be found? I mentioned earlier, I'm going to repeat it again. There is a website, eccourts.org. And that is the website for the Eastern Caribbean Supreme Court. And one will find there the practice directions and the sentencing guidelines and lots of examples of sentences which have been passed as judgments by the High Court across the various islands, not just St Kitts and Nevis. It's all there. Folk don't need to rely on a bit of gossip and a bit of chit-chat and a bit of WhatsApp and a bit of Facebook and a bit of discussion down the rum shop. There's stuff there online for people to see and better inform themselves and to demand that is information that the lawyers have looked at, so everybody is on the same page. And for example, the sentence indication practice direction is direction number 2 of 2015. It's on the website. The sentencing guidelines, they're on the website. Everybody can have a look. You can do a lot of the work yourself and see how things work. It's pretty straightforward. It's not complicated. You don't need a law degree to be able to follow the guidelines, and that's the point. They're for everyone to be able to contemplate. They are not simply for the lawyers. And so I'd just like to emphasize, before I return the baton to Deniece, that there's a lot of things that can now take place by way of discussion and negotiation within the structure, the 6 steps structure of the sentencing process. It's no longer a mystery, and folk can expect the lawyers to have an understanding of where the case will fall within the sentencing range. So I hope that helps to clarify and add to some of the things that have been said by the DPP. And I'll hand the baton back to you now, Deniece.
Well, before, I just want to clarify something that was mentioned by Judge there. Judge made reference to starting point being a percentage. I just want to indicate at this particular point that when you look at the sentencing guidelines, we have to remember that barring the guidelines which are for particular countries, the guidelines apply to the rest of the Eastern Caribbean countries. And when they talk about percentages, we're talking about percentages of the maximum sentence. Like, for example, an offense may be liable on summary conviction or conviction and indictment for a term of 5 years, 10 years, or not exceeding 5 years or 10 years. Whatever that number is, that is always the maximum sentence, right? So a starting point may be a certain percentage of the maximum. The range would be a certain percentage of the maximum as well too. So it's important to understand that, because within the Eastern Caribbean itself, for different types of offenses, countries have different maximum penalties. So it's put in terms of percentages of the maximum. That's an important thing to understand. And for practical purposes, like, for example, rape carries a maximum of life imprisonment. How do you calculate like 20% of life imprisonment? Well, for the purposes of the sentencing guidelines, life imprisonment for the purpose of that calculation is 30 years, right? But that's just for the purpose of determining what the percentage is according to the guidelines. And for practical purposes, for the people of St. Kitts and Nevis, if you are an accused person suffering under a charge, if I can put it that way, how do you find the law? Number one, well, the laws of St. Kitts and Nevis are available on the Law Commission website. I think it's lawcommission.gov.kn, right? And you can look up legislation there to find where the maximum, if you want to do this yourself without legal advice and you wanted to find out what the maximum of the sentence is, generally your charge would indicate contrary to a particular section of a particular legislation. Well, you look for the legislation on the website, you look for the particular section that you're charged under, and that will make you find the maximum sentence. And the last thing I want to underscore or point out or support the judge in saying that it's important for lawyers to talk, to make this process work, because guilty pleas have a way of reducing delay and backlog in the court, as previously alluded to. And I'm a protocol kind of guy. I like to sit down and put protocols together to help achieve efficiency. And so, among other things, I have a protocol which has encouraged my attorneys, my fellow Crown Counsel, to actually write to counsel indicating at the earliest available opportunity whether you're minded to take a plea in situations where you have alternative offenses. And doing all of this can help reduce the amount of time that we spend in court on a particular matter, which of course has its spin-offs in terms of benefits for reduction of the backlog in a particular system. I just wanted to make those few points.
Now, before we get to questions, because we have some pretty good questions from the public, one thing I think we should discuss is the nature of sentencing. We hear sentence and most of the people will think prison.
Yes.
But of course, that's not the only sentence that is available. We have custodial, but of course we have various forms of non-custodial sentences. Restitution, so other forms of sentences. So I would like to, for you all to discuss the different kinds of sentences that are available and how the guidelines deal with them.
Well, if I can assist there, there are other things that can happen to folk than go to jail. First of all, in theory, a very minor offence might be conditionally discharged. That is to say, no action taken, providing you keep out of trouble for, let's say, 12 months. There can also be a fine. That's a financial penalty. You're required to pay some money to the government. There can also be, as part of a fine, there can be perhaps additionally some compensation payable to somebody who may have had something taken from them. There is then also probation, which is available, where a person is monitored by the probation service and they get counselling and they receive some form of interaction to discuss their offending behaviour, some sort of support so that they change their offending behaviour. And in the event that they don't do the probation that's required of them, let's say they have to attend the probation office once a week for a year or so, if they don't do what is required of them by the probation officer, if they don't attend, then they can be breached. That is to say, there can be a report filed to say that they are in breach of the probation order, and they can then be resentenced. And in those circumstances, they'll probably go to jail. And there's also a community service order potential, which involves somebody working for a public institution. They could be, for example, helping to clean school yards or helping to strip back the foliage near roads. And they would do essentially unpaid work for the community. And this is a type of sentencing which needs to be developed further here on St Kitts and Nevis, so that there is a strong range of unpaid community work which can be done by persons ordered to do what's called community service. After that, we get to prison sentencing. And with regard to prison sentencing, there are two options. If a case is deemed to warrant a prison sentence because it is serious enough not to be dealt with by a conditional discharge of fine, compensation, probation, community service, it's serious enough that it merits prison, then there is, do you serve the sentence immediately, or can the sentence be suspended for a period of time so that you don't serve the sentence unless you get into further trouble? And if you do, you serve the sentence on top of whatever else you may face. And there are guidelines as to how to determine whether to suspend a sentence or whether to impose an immediate custodial sentence. But a suspended sentence is a sentence of imprisonment which you don't have to serve just yet. That is part of the armoury available to the court. And then, of course, there is simply a prison sentence. And the prison sentence is calculated by, as we've described, the 6 steps and reliance on the guidelines. So I hope that gives you some idea, Deniece, that not everybody goes immediately to jail once they appear in court. There are other options which need to be explored by the lawyers and can be part of the plea negotiations in order to perhaps reduce the seriousness of an offence if that is agreeable to all the parties. So I hope that helps set in context. It's not always jail.
Now, moving right from that point, there's one other point I think we really should touch on before we get to the questions. And that is, Your Lordship mentioned that the second aspect of the sentencing guidelines is assessing the offender. Now, there are 2 special cases of offenders that I think people would be interested in: juveniles and people with mental disease. And how so if you can give us a little bit of the guideline, how the guidelines address those 2 particular special cases.
Right. Well, a great question, and it throws up a point to focus on here. Regarding juveniles, under the practice direction, juveniles are to be treated more leniently if it is possible. And specifically, if a juvenile has committed a very serious offence, then depending on the age of the juvenile, there is a further discount applied to the amount of time that they would serve. So somebody between the ages of, I think, 17 and 16 would serve 2/3 of what an adult might get if it's a very serious offence. And somebody under the age of 15, down to what's called the age of dolly incapax, meaning the age of not being criminally culpable, which I think on this island is the age of 12, I think that's right, they would serve half of what an adult might serve. Now, there is a limit, however, to where folk who are juveniles can be held. As I understand it, it's currently at the New Horizons Centre. And there would be, in other Commonwealth countries, different facilities available for juveniles. But we're limited as to our facilities here. But it needs to be understood that the first step of the juvenile is you're always looking for leniency. You're always looking for a way of not putting a juvenile in jail. So a juvenile will more often not go to jail than an adult. That's the first point. And then the second point is, if you are a juvenile and you are going to jail, there is a discount which is built into the sentencing process because you are a juvenile. And a juvenile is essentially a person under the age of 18 for sentencing purposes. System isn't perfect here, but we have improved the understanding of how to approach sentencing for juveniles. Let's talk now about mental health. There are, to my observation, 3 years into the job here, mental health issues on this island, where there are people who are before the court with mental health problems. Folks should not be frightened of mental health issues. It's said in studies that 1 in 4 people will suffer a mental health problem in their life, which they'll recover from, but not always, but most people will suffer a mental health problem which they will recover from. It's often said people have a nervous breakdown, for example. That's something you hear it on the TV and a bit of chat amongst friends. That's a mental health problem. And there are other ways of describing ordinary activities as a moment of, or a period of, a degree of mental illness. A person with a mental health problem is not a lunatic who is going to kill everyone. It needs to be understood that mental health people, got problems, they need support. And there are some people who are very dangerous, yes. And the courts need to be able to identify them, and there needs to be a strong system of psychiatric review when you're dealing with people who've been accused of serious offences with mental health issues. But I want folk, if I may, and I hope this is a message which is broadcast far and wide, mental health issues do not mean a person is a murdering lunatic, right? There can be such people, but it does not apply to the vast majority of people who've got a mental health issue. Now, let's talk about the person who really is dangerous as a result of mental health issues. There are a few of them, and they do come into my courtroom. And the frustration here on St. Kitts is we don't have a mental health secure hospital. And additionally, we don't have strong mental health legislation. So that, for example, I can't pass what would be called a hospital order under restriction, as would happen in the UK and in other Commonwealth countries. Well, what you can say is somebody commits an act of a certain level of seriousness with a certain level of serious mental health issue, and rather than just send them to jail, you would send them to a psychiatric hospital where they're locked in, but they receive treatment. And they're not allowed out until 2 doctors plus the Attorney General here are satisfied that they're reasonably safe to be allowed back into the community. And that would then involve tying their being back in the community to the probation service so that they monitor them. And if there's any breach in their behaviour whilst released under the probation authority, under the licence to be back in the community, if there's breach of behaviour, they go back to the hospital. It is a difficulty. It's something that the government, I've no doubt, struggles with. Hospital facility and mental health legislation. Because right now, a person who is dangerous as a mental health person, a person with mental health illness, that person can only really be sentenced to being kept in jail. And they would receive medication from the medical authorities whilst they're in jail. But you end up passing a jail sentence in respect of people who really ought to be in hospital. So there is an issue about this, and it's often the case that people in the criminal courts have mental health issues. But as I say, many of them are not murdering lunatics, and we need to understand they need support. And those who are dangerous, we need to understand we need a hospital with proper mental health legislation to allow hospital orders with restriction. So I hope that answers the query.
It certainly does. Now, given the time, I will get into the questions. Now, the members of the public sent questions to the Bar Association website. And the first question deals with suspended sentences. Why do some prisoners get suspended sentences and others do not when they are convicted of the same crime?
Well, if I can come straight to that, because it's always an interesting subject and it occupies a lot of a judge's time. There is a practice direction, number 3 of 2019. And I'm just going to read it. It's quite short, but I think people will find it easy to understand. It's not all very legal jargon mumbo-jumbo. It's very straightforward. It says, in certain circumstances, a sentence of imprisonment may be suspended. A suspended sentence remains a prison sentence and should not be passed unless a term of imprisonment is warranted. It should not be considered another form of non-custodial penalty like probation or community service. Subject to local legislation making it permissible, it should be considered rare to suspend a sentence of more than 2 years imprisonment, and rare to suspend for more than 2 years. Now, I'll just pause there. Here on St Kitts, you have an act which allows a suspended sentence for up to 3 years, but the sentencing guideline, practice direction, contemplates 2 years, subject to local legislation, which you have here, the local legislation allowing up to 3 years. So, in other words, if you're going to get more than here on St Kitts, if you're going to get more than 3 years, it's not going to be suspended, because it can't be. If you're going to get 3 years or less, consideration can be given to whether or not it is suspended. It doesn't mean it will be suspended, but it can be considered for suspended sentencing. And so how to look at it? Well, the court may consider, I'm now reading from the practice direction again, the following non-exhaustive list of factors in exercising its discretion whether to suspend a sentence. First, can appropriate punishment only be achieved by immediate custody? Second, does the offender present a risk or danger to the public or to the victim? Third, has there been a history of poor compliance with court orders? Fourth, is there a realistic prospect of rehabilitation? Fifth, if sentencing a person under 21, is there a realistic prospect that incarceration will so affect an offender as to turn that person more towards criminality and less toward rehabilitation? Sixth, is there strong personal mitigation? And seventh, what will be the impact of an immediate custodial sentence on dependent relatives, employees, and the community? So, without going through the rest of the direction, you can see that these are factors that a judge has to weigh in considering whether or not a sentence can be suspended. And what you're doing is you are weighing, on the one hand, is this an offence for which only an immediate custodial sentence is justified, with, on the other hand, are there other features to the offender and the offence which allow there to be consideration for suspending the sentence of imprisonment. And I hope that helps. I don't know if the DPP has any further thoughts about it.
No, I don't have any further thoughts. I think you've handled that issue very well.
Okay, well, sticking to the theme of what judges consider, one of the questions asks about the unwritten factors that go into the process where there are special circumstances in the offense, such as offenses committed by parents against their children. See if you can speak to that.
Sorry, I don't understand the question.
So the question is, do judges take implicit factors into account when sentencing? For example, as it relates to violent crimes committed by parents against their children.
I don't understand the nature of the question. Are we imagining that there is a different categorization to an offence because it's a parent on a child, the child of the parent? Is that what's meant by, did you say implicit?
Implicit, yeah.
Implicit what?
Implicit factors.
Factors. Mm-hmm. The factor which is implicit is what? That there is the relationship between the parent and the child. Well, of course, that is going to be something which will be factored into any sentencing exercise. It is a feature of some cases that it's an example of over-discipline in respect of a child. I think there was one case in Antigua, the DPP may remember there, somebody broke his child's arm for not doing their maths homework properly. And more recently, there has been a case here of there being a child who was scalded as a result of a moment of ill discipline and poor behaviour at home. And these are examples of where the event has been brought to the attention of the authorities, usually by the school, who see that there's an injury and therefore they're under a duty to report that there is an injury, which is said on inquiry by the teacher, this happened because of my relative, my mum, my dad, or some other member of the family. And then there is an inquiry by the police, and there is perhaps, in extreme cases, a prosecution. And then the question is, well, does it matter that one is dealing with a child, the natural child of the defendant? Of course it matters. It becomes part of the sentencing assessment. And that becomes part of the assessment of the offence and also part of the assessment of the offender. It's relevant to both steps 1 and 2. So yes, it is I think you called it an implicit factor. I think what we mean to say is it relevant that that's your child? Of course it's going to be very relevant. I don't want folk to imagine that their kids can put them in jail. That's not the way things are supposed to work. But if there is over-discipline, which results in serious harm to a child, then you can expect to be prosecuted.
Now, this other question, I think it's quite common. If someone is convicted of a crime to do with theft of money, can they escape jail time if they pay it back?
Well, again, if I can come back on that, it depends on the case.
The amount?
It also depends, this is an important feature, it also depends on what the victim is asking. You see, there can be some cases where the victim is saying, look, I want the money back, I need the money. And it becomes relevant to the whole process as to how to deal with the case if by putting the person in jail, they're not able to earn any money to pay the individual back. They lose their job as a result of being jailed. So it's a factor that needs to be taken into account. What does the victim have to say? And then when the victim has whatever they have to say, the court still has to make an independent assessment of whether or not paying back the money is the right way to deal with this case, if that's what the victim is asking, or whether or not, no, this case is so serious that the matter needs to go to a custodial sentence. Query, is it suspended? Is it suspended with an order to pay back the money, or is it an immediate term of imprisonment? But it needs to be understood, I think, that the court tries to take into account lots of different factors, and one of the factors thrown up by the case you've just mentioned to me, is what does the person who wants the money back say? So I hope that helps. I don't know if the DPP's got any thoughts on that.
I'm considering, for example, if you have a situation where the person may be a repeat offender, just constantly stealing, and the context in which the stealing takes place, if it's in the course of employment. I mean, if you're stealing from your employer, that's a serious breach of trust, and so on. The point I'm making is that there are a lot of factors which go into, and just highlighting the complicated nature of sentencing. Sometimes it's not just a simple yes. If the victim says, I want the money back, the court will always grant. I don't want anybody to get that impression at all.
Yes, and if I can add, neither do I. It's still the court's decision.
Right.
But it may be useful to know what the victim is saying.
Yes.
I think that was the point, because it's often, I've actually had people come to my office to say, I take this money from this person, but can't you just tell her I can give it back to her, and let's make an arrangement. People do that, so it's a way they think, and I try to tell them I cannot do that. Right? Yes.
But maybe that's another discussion for another day. But this making arrangement thing, in Antigua we call it making up the case. Mm-hmm. Technically, a person who is engaged in that kind of thing, and particular attorneys and so on, you're running the risk of charges of perverting the course of public justice or justice interference, because you will have a situation where a person, if that kind of conduct were to continue, they may think that they can steal in the future
and just
even more, and then you just simply pay off the person and you don't end up before the court. And then, of course, when that happens now, the court isn't seized of, the prior criminal offending of the individual because it is kept in secret. I mean, we believe in open justice here. So I'm just putting that warning out there, right? Don't make up cases. You are running a serious risk.
Now, this other question has to do with something that is quite emotive, and that's the death penalty. And I think this is perennial now. Why isn't it applied in more murder cases?
All right. Well, I can understand why the issue of the death penalty may be an emotive issue. It brings up all kinds of different feelings in all sectors of society, especially in places where murders are prevalent. And I would imagine even more so in St. Kitts, which has St. Kitts and Nevis, the Federation, which has one of the highest murder rates in the world for such a small population. Let me start first by saying that there was once upon a time when the death penalty was mandatory. In other words, murder committed in whatever type of circumstance, right? It merited the death penalty. It was automatic. However, in around 2003, there was a trilogy of cases or decisions from the Privy Council which struck down the constitutionality or legality of the death penalty. The case of Bertil Fox, Patrick Reyes, and Newton Spence, I think. And those cases, as a result of those cases, the death penalty was abolished, and the courts now had to consider the mandatory death penalty. I'm sorry, context. Yeah, the mandatory death penalty was abolished, and so now the courts had to consider the circumstances of the commission of the offense and the circumstances of the offender in terms of constructing a sentence for murder. And then along came the case of Daniel Dick Trimmingham, which basically laid down the principles that the court has to apply in determining when the death penalty is supposed to be imposed. All right? Before going into the principles, let me talk a little bit about the facts of that particular case. A 68-year-old man was killed. He was lured by, I can't remember the relationship of the person to the accused, but he was lured by the accused to a particular area where he was pounced upon, chopped up several times with a cutlass. His neck was slit. Then his head was cut off. He was thrown into a ditch of sorts, and I think the body might have been burnt or something after that. And one would have thought in those circumstances that was something which merited the death penalty, all right? 68 years old. The Privy Council said, look, when it comes to imposing the death penalty, first of all, the court has to be satisfied that the particular instance of offending falls within the worst of the worst or the rarest of the rare cases of murder. All right? Now, one would think, okay, the worst of the worst, rarest of the rare, that might apply to the particular jurisdiction. Because in, for example, St. Kitts and Nevis, you may have worse up to a particular point. But maybe in a case like America or some other first world country, you have things like terrorism and so on. You don't really have a lot of terrorist offenses, if any, here in the Caribbean. So the Privy Council says, no, it's not limited to the local jurisdiction. You compare it with the worst forms of murder that exist in the world, so to speak. So that's the first threshold you have to pass. Right. Yes. So, you know, there has been a situation whereby in Antigua, I think I had 2 murder convictions, one a man, one a woman, where I did apply for the death penalty. And the only prosecutor was brave enough to apply for the death penalty. And I remember the struggles I had in terms of dealing with the principles that the Privy Council has laid down. But then anyway, the worst of the worst, rarest of the rare. And I always made the point that that's a test that's difficult to satisfy. Because let's say, for example, if you shoot a person even 100,000 times, you can always add one. And it gets worse and worse incrementally. I think a more fair or just or reasonable system would be a system where there are thresholds. In other words, if there's a particular threshold of violence, then that invites consideration of the court in terms of determining whether to impose the death penalty. But anyway, worst of the worst, rarest of the rare. That's the first test. Let's say perchance that you can get over that first hurdle, if that is possible. There's still a second limb that the court has to consider. And what is that? There must be no prospect of rehabilitation. Right? And the thing is, in both instances where I had applied for the death penalty, the probation officer said there was prospect of rehabilitation in any event. And I want to believe, barring a situation where you have multiple convictions for serious violence, right, there will always be some sort of prospect of rehabilitation. So, bearing in mind those two principles, and also too, I must indicate that where the death penalty is being sought, it's the prosecutor that has to apply for the death penalty. It's not something that's automatically imposed by the court. The prosecutor has to apply for the death penalty. But of course, when we consider the hurdles that we have to face, it really makes no sense. And it makes you wonder if the Privy Council has not, in effect, abolished the death penalty for us by making the test so high. But that's a discussion for another day. So to answer the question, because of the impact of that case of Daniel Dick Trimmingham, I think that's either 2005, I think, Privy Council case. Right, because of the impact of that particular case, it has made it difficult for the courts to impose the death penalty. Not to say that we won't ask for it, nonetheless, in circumstances where we think, because if we don't try, we won't know what the Court of Appeal might say, and unless things are tried in the courts, I mean, there's no way of developing the jurisprudence by way of the appeal process and hearing what the appeal court has to say. So that's my response to that question.
Now we are at 11:30, but we have been given just a couple more minutes, and I know His Lordship is a bit pressed for time, but there was one question that I really think he should address. There's a current issue. It's current, and it's something I think people are concerned about, and that is judge-only trials, and whether they should be, and whether is that something quickly people should be concerned about. I really, it was newly passed. Yes. I think just a couple months ago.
Well, if I can help, and I'm terribly sorry, but I'm due to continue a summing up with the jury in my court in 10 minutes' time. So I do have to leave. We were expected to finish at 11:30. I think we're just gone 11:30 now. But you're raising a question which is not on sentencing. You're raising a question which has quite a lot of politics behind it. And it's not my role to express a view on any of the politics. What I can say is that there has been a change in the legislation with a new act which allows judge-alone trials since the 30th of September. So it's not yet 3 months old. And it is a new piece of legislation which all the lawyers and the court are working their way through. And it allows for judge-alone trials in certain circumstances. It is new, and we will see how it evolves.
And on that note, if there is any other point the DPP wishes to make to...
Well, yes, there is one point I want to make, because I suspect the issue may come up in the future, and that is public reaction to judicial sentences, right? We live in a technological age where we like to exercise our right to freedom of speech and so on and so forth. And I'm speaking against the backdrop of what I've experienced in Antigua. Particularly where sexual offenses are concerned, a lot of emotion concerned with that and so on. But at the same time, one has to be careful with how one criticizes a judge's decision. I want to start first with a principle coming out of a case called Ambad and the Attorney General of Trinidad and Tobago. It's around 1936. The Privy Council in that case says that justice is not a cloistered virtue, it's not a sheltered virtue. It must be allowed to suffer scrutiny. And the fair criticisms, even outspoken, of the ordinary man, right? But these criticisms have to be made in good faith, right? When you start going down the road of impugning the integrity of the court, the impartiality of the court, without evidence, you are running the risk of being prosecuted for contempt of court. And what is worse is if you're doing it in the context of using social media and so on, you could potentially be charged with unlawful communications by sending menacing messages or intimidating messages to the public or whoever at large concerning something in relation to a judicial decision, especially if that if that judge suffers emotional distress as a result of the communication. The penalty for that is up to 2 years imprisonment and $15,000, and I'm sure a lot of us don't have that kind of money lying around. The point I want to make is there is nothing wrong with critiquing a judge's decision. However, one must make sure that the criticism is fair, it does not have overtones of malice or ill motive associated with it, no imputation of bias or corruption or payoff, unless, of course, you have evidence. That's a different situation altogether. But if you do that, you are running the risk of coming before the courts for contempt of court. That is the warning shot. A word to the wise is sufficient.
And on that note, I would like to thank the members of the general public who took the time to send in their questions, and thank our distinguished panel for the participation here this morning, and for giving us a lot of food for thought. Very, very informed discussion. And we look forward in the future as the Bar Association to bringing this kind of content to the public on other topics, and furthering more discussion. So thank you very much again for listening, and good morning all.
Thank you.